In the previous video, what we did was spend some time talking about the concept of mediation as a method of dispute resolution, arguably the least formal and most simple type of dispute resolution that we see on the SQE specification. This lesson is going to ramp it up a little bit and talk about arbitration, which is a sort of middle ground between your mediation, which is very, very informal, and litigation, which is very, very formal. You sort of have arbitration that sits in the middle. Now, essentially, we're going to be following the same part of the specification as we have been over the last couple of videos, talking about the different types of dispute resolution options which are available to a potential client, alternative dispute resolution, mediation, arbitration, litigation, etc., etc. And we're going to spend some time outlining in this video the process of arbitration, talking about what arbitration is, what are some of the key features of arbitration, and what are the advantages and disadvantages of arbitration as a process for resolving a dispute. So let's get started then. Arbitration is, as I've just mentioned, a more formal method of dispute resolution than negotiation, which we haven't dedicated a whole lesson to because it's not part of the specification, and also because it's very, very simple. It involves the two parties negotiating with each other. Nor is it more formal than mediation. So mediation is also less formal than arbitration as well. Mediation is, of course, what we focused on in the previous video. Essentially, then, in arbitration, we have a situation in which the parties will agree that their dispute will be submitted to somebody called an arbitrator. Now, an arbitrator might be more than one person in a lot of situations, especially very big cases, very, very complicated cases. You might have a panel of three that deal with the particulars of a case. Now, some argue that it is somewhat similar to litigation, and in some ways it very much is. But while it is more formal than mediation, it is more flexible and less formal than litigation. So litigation is quite rigid in terms of the processes that have to be followed and in terms of the ways in which it has to be carried out. Whereas arbitration, while, like I said, being more formal than mediation or negotiation, is definitely more flexible than litigation. So, usually arbitration will take place when the parties to the dispute agree that they want their dispute to be submitted to arbitration. So they have a dispute, maybe they've done some negotiations, maybe they've sent some letters back and forth, maybe they've even got a mediator in to try and resolve the dispute and they didn't actually manage to do so. And so the next step is, okay, well, we don't really want to litigate because that's quite expensive and that's quite long and it's not particularly helpful in some cases. So let's see if we can't resolve the situation with a slightly more formal process, the process of arbitrating. Let's submit our case to an arbitrator. Now, most of the time, arbitration will take place in situations where the parties are actually contractually bound to submit to arbitration in the event of dispute. So in a lot of contracts, especially things like maritime contracts and commercial construction contracts, things like that, there is a clause within that contract that basically says, if there is a dispute that arises between me and you in the event of whatever the doings of this business, then it will be the case that we will submit this dispute to an arbitrator. This is sometimes known as an arbitration clause. Now, alternatively, where such clause does not exist, it might be the case that arbitration is just agreed to by the parties to a dispute, similar to that of mediation. So, let's say a arbitrator has a very specific expertise in the issue that the dispute is about. And in those cases, it might be seen that, well, if there's no arbitration clause here in our contract, but nevertheless we want to try and submit this case to an arbitrator, and so long as both parties agree to that particular endeavour, then that is perfectly fine. Now, an arbitration clause, of course, requires the agreement of both parties because it requires the agreement of both parties to even sign a contract in the first place. But fundamentally, then, arbitration can take place through one of two methods. It arises most of the time if there is a clause in a contract already that says where a dispute exists, we will then submit this dispute to an arbitrator. As I noted at the bottom here, there will be arbitrators that often have a specific amount of expertise in very specific fields of law, very, very technical fields of law that, in my opinion, are quite boring. So things like shipping contracts or procurement contracts or construction disputes on engineering and construction contracts. These are all the sort of finicky commercial technical contracts and bits that I personally don't find very interesting. But if you find that interesting, then hey, maybe one day you could become an arbitrator in those kinds of disputes. Now, a lot of the arbitration law that is associated with this area is regulated by the 1996 Arbitration Act. It largely regulates the conduct of arbitration, although it does so with reference to agreements to arbitrate which are made in writing. So it is limited to that type of arbitration, although that type of arbitration is quite common where arbitration arises. Section 6 of the legislation says that an arbitration agreement means an agreement to submit to arbitration present or future for present or future disputes, whether they are contractual or not. The reference to an agreement to a written form of arbitration clause or to a document containing an arbitration clause constitutes an arbitration agreement if the reference is such as to make that clause part of the agreement. So technical stuff about what an arbitration agreement actually is, defining these different kinds of things. Moving on then, the process of arbitration. What does it actually look like? What does it actually involve? Well, the first point is that there has to be an agreement to arbitrate. That's the first stage of the process. Whether that agreement is contractually enshrined in the agreement to contract with that person with an arbitration clause, or whether or not there is an agreement to arbitrate between the parties after a contract has been signed, is irrelevant in this particular process, and so ultimately the agreement to arbitrate is the first stage of the process. The next stage is the selection of arbitrators. So the parties here will then choose who they want to be the arbitrator. Or alternatively, if it's a particularly big case, they might choose to have a panel of arbitrators, because 3 people arbitrating on a case might be more conclusive of an answer if they all agree on one particular outcome rather than just one single individual. So usually arbitrators will have expertise in the subject matter, so they will be experts in public procurement law, they'll be experts in maritime shipping law, they'll be experts in consumer or construction contracts law and all these different kinds of things. And so they are able to hand out some of their expertise to the process of dealing with this arbitration. The next stage is, once you have got yourself an arbitrator or some arbitrators, you will then have a number of hearings. This is where the parties will present evidence to the arbitrators. The arbitrator will hear the evidence, of course, they will listen to witnesses, etc., etc. This is quite similar in style to formal litigation, but again, it's less formal in the process that it is arbitration, it is not litigation. But in a similar way, there is the presenting of evidence, which is what you would see in litigation. And then after the evidence has been presented and the case has been presented on both sides, the arbitrator will then retire to write up and to conclude their decision. After considering the evidence, they will make the decision. The decision of an arbitrator is what we call an arbitration award, or just an award for short. So the award is who is awarded the essentially the win in the arbitration, fundamentally. So with all this being said then, what are the advantages and then what are the disadvantages? Just like with mediation, there are advantages and there are disadvantages to all of these different types of dispute resolution processes. Well, in terms of advantages, just like with mediation, arbitration is often quicker and more cost-effective and often easier than formal litigation. It's more costly than mediation, but it is less costly than litigation. And so you might find that if you want a slightly more formal process than mediation, that has at least more formalities involved, that might bring you a more conclusive result with somebody who is actually an expert in that field, and you want to do so but not at the cost of litigating, then arbitration might be the option for you. Arbitration usually involves an award being made by an arbitrator who has expertise in the subject matter that the dispute is about. This usually results in a judgment that is reasoned based on the expert consideration. So that's also a very important feature of arbitration compared to mediation, in that the mediator is just trying to get the parties to agree to an amicable conclusion. The arbitrator is trying to come to a conclusion as to the correct course of law in this particular dispute. And so in that particular dispute, they will give a reason why. They will write a written judgment, basically, or a written award. And you can read some of these awards. In a previous life, I did quite a lot of work in international investment law and investment arbitration stuff. And reading arbitration awards is something that I did quite a lot of, and again, it was particularly boring disputes, but fundamentally it was disputes that gave reasoned decisions. The arbitrators gave reasoned decisions in the context of which I was researching it. It was, of course, in an international context, looking at ICSID and UNCITRAL and all these different kind of very large arbitration institutions, but it needn't be that large and multifaceted. But fundamentally, the result is that you get an expert consideration and a reasoned judgment. It's also the case that the awards that result from arbitration are in fact binding, meaning that the parties are obliged to implement the decision. So it provides you with the kind of benefit of having some kind of solid conclusion that you would not get when you are mediating. The mediators can just leave whenever or the people to a dispute may just leave the mediation process whenever they so choose. And they don't have to come to a conclusion. You would then be forced to either take the case further to actual more formal process, or just give up on the case. Either way, it's not a very satisfactory result. At least with arbitration, then, you get a result that is binding on the parties. But like with mediation, there are also disadvantages. Despite involving an expert on the subject matter, for example, arbitration awards usually don't result from the same depth of investigation as you would get if you went down the road of litigation. So there has to be a breaking point eventually, is what I'm trying to get at. You can't have the same kind of sophistication and the depth of investigation that you would get in litigation for half or even less than half of, more than half of the price and the cost effectiveness and the length of time that you get. Fundamentally, one of the very features of arbitration being cheaper and quicker means that the depth of investigation that you get from arbitration is not the same as that of litigation. A further disadvantage is that while it is definitely cheaper than litigation, it is still quite costly. It takes quite a lot of time to get an arbitration panel. Arbitrators often are very well paid, especially in these very big cases, and there's a lot of processes that need to take place in terms of getting evidence gathered and all this kind of stuff, and so the process is still quite costly compared to mediation, for example. Again, while generally cheaper than litigation, it can still be quite costly. And I believe in some cases it might even be more expensive than litigation in the long run, when you have really big cases, where you have really big international investment cases, for example. They might even be more expensive, but I'll have to check. And then the final disadvantage is, since it's more formal than mediation, it is less accessible for individuals in smaller disputes. Notice that the conversation we've been having concerns things like public procurement contracts or shipping disputes or construction contracts. These are often quite big things. They're often big firms that are involved in quite large contractual obligations, very, very technical details and all these different kinds of things, often involving millions of pounds in a lot of these situations, like public procurement, for example. Procurement contracts often cost millions of pounds of taxpayers' money. And so ultimately, the very nature of arbitration and the nature of the kinds of disputes that are dealt with through arbitration are actually less accessible to smaller individuals. What if you are just if you're just a small individual, if you're just a small company, or you're a sole trader that is looking to resolve a dispute? Well, that might be more difficult to do through arbitration.